Hi, I'm Kent Berk, attorney at the Berk and Moskowitz law firm in Scottsdale, Arizona, where we handle real estate, probate, and other types of disputes. I'm going to explain today what happened in the Gold versus Helvetica Servicing Company. This case was decided by the Arizona Court of Appeals on April 3, 2012, under Arizona's Judicial Foreclosure statutes. Now, Arizona has two types of foreclosures, trustee sales and judicial foreclosure. Most of you are familiar with a trustee sale, as there's been a lot of information in the newspapers and in the media about all the foreclosures that have been happening. The typical way for a lender to foreclose is by trustee sale, where after a borrower defaults, the lender issues a notice of trustee sale and proceeds without filing any lawsuit or anything, issues a notice, and at least 90 days after that notice can simply hold an auction, for example at the courthouse steps, to sell the property in partial or full satisfaction of the debt. This Gold versus Helvetica servicing company involved a judicial foreclosure where the lender actually filed a lawsuit for the court to declare the amount that was owed on the loan and to get a court order where the sheriff, instead of the lender, would hold what's called a sheriff's sale, or the auction, where the property was sold. And in this case, the court found that the Pasquans owed a total of $3.7 million on their loan, and Helvetica got an order allowing them to have the sheriff auction the property. At the auction, Helvetica bid only $400,000 and was the winning bidder at that price. So the sheriff issued what's called a certificate of sale at the sheriff's sale auction, and that then triggers, under the judicial foreclosure proceedings, a 6-month right of redemption where the borrower or a successor in interest to the borrower can buy the property for the purchase price bid at the sale, in this case $400,000 plus 8% interest. So the borrower also has another, the reason for that is so that the borrower is protected from the lender making a low bid at the sale and thereby increasing the amount of the deficiency that the lender would then also pursue collection of against the borrower, or the Pasquans in this case. The borrowers also have another remedy to prevent or protect against the lender bidding too low at the trustee sale or the judicial foreclosure sale, and that is a right within 30 days of the sheriff's sale to ask for a fair market value determination. If the borrower requests a fair market value determination, then the court has to hold a hearing, and the borrower is entitled to a credit for the amount bid at the sheriff's sale or the actual fair market value determined by the court, whichever is greater. And in this case, the court ultimately held a fair market value determination and found that the true fair market value of the property as of the time of the sheriff's sale was $2.3 million instead of $400,000. The problem was that Mrs. Pasquan and Mr. Pasquan had filed for divorce. Mr. Pasquan is the only one that asked for the fair market value determination. Mrs. Pasquan assigned her right to redeem the property, to buy back the property or the certificate of sale from the lender that was the winning bidder, so that Mr. Gold could exercise the right of redemption and then lease the property back to Mrs. Pasquan. So in this case, the borrowers, one had requested fair market value determination and the other one was pursuing to redeem the property. And the court held that those two protections, fair market value determination and right to redeem, are separate and mutually exclusive. So if you exercise one, it prevents the other. And since Mr. Pasquan had first demanded a fair market value determination and Mrs. Pasquan didn't object to that, the court held that Mr. Gold, as Mrs. Pasquan's assignee, was not entitled to redeem the property. So Mr. Gold's action to be awarded the property after he paid the purchase price of $400,000 plus 8% interest was denied, and the Court of Appeals in April 2012 upheld the dismissal of Mr. Gold's action to be awarded the property. So in the end, Helvetica was the winning bidder and got the property, but the court determined that the $400,000 bid price was too low and that the Pasquans were actually entitled to a $2.3 million credit against the total amount of the debt, and the Pasquans then ended up with a deficiency of $1.4 million. Now there's another case that was decided by the Court of Appeals between the Pasquans and the Helvetica Servicing that I reported on in another blog entry that you can learn about on our website, arizrealestatelaw.com. And please monitor our site, as we will be posting updates as additional decisions are decided by the Arizona Court of Appeals and perhaps the Arizona Supreme Court. If you have any questions, please give us a call. Thank you.